Hey, Tabitha, are we ready? Mike, can you hear me okay?
Yeah, I can hear you.
Okay.
I can't. Tabitha's still muted though. I'm not
Okay,
sure.
I assume.
I've got it now.
Well, okay, I think we're ready to go, Tabitha, unless
Okay.
you tell me otherwise. Okay. Well, I want to thank everybody for joining us today. This is Robert Smith with Friday Eldredge and Clark in our Little Rock office. Also have Mike Moore on the line. Also in Little Rock, Mike is in our labor and employment group, and we appreciate the opportunity to present to everybody today, and have had the chance to host several of these with the Bankers Association, and we appreciate that relationship, certainly. We have, like you all, I'm sure, have been consumed over the past several months with various business and personal changes that the virus has brought to bear, and we felt like it'd be a good opportunity today to just talk through some of the, not necessarily programs so much and different things, but kind of the risk aspect of some of these things that we've been dealing with, from the Paycheck Protection Program, which I've had an opportunity to work on quite a bit over the last few months, to some of the reopening business issues, as you know, our business and many businesses throughout Arkansas are struggling with the issue of reopening safely and protecting employees and customers and so forth. So we thought it'd be a good opportunity today to discuss those points. With respect to the Paycheck Protection Program, I read this morning that there have been a total of 4.4 million loans approved and just over $500 billion actually funded to date. So there's obviously still some funding available. We have seen some things develop over the last few months as the program has been implemented. As you know, the SBA and Treasury every week or so, it seems like, has issued some sort of guidance, either in the frequently asked questions that they continue to update, or in the format of interim rules. It's been a rough implementation, as you're well aware, I'm sure, under the PPP. Bank clients that we talked to initially and really throughout the process felt more kind of forced to voluntarily participate in it, just to accommodate customer needs and that sort of thing. But it has raised a lot of different questions and issues concerning what risk banks are taking by participating in the program. And so on the next slide there, Tabitha, on the front end, one of the questions that we received and we had was just what diligence is a bank required to do from just a normal underwriting standpoint. If you watched CNBC and other media and read about the program when it was initially discussed and then when it was enacted, these were pitched as grants essentially, or just loans intended to convert to grants once the forgiveness and the covered period expired, and kind of a no questions asked approach to it. There have been a ton of articles written on fraudulent loans. There have been, the Department of Justice has taken action against, I think I've seen 4 or 5 different cases that they've opened where individuals were essentially committing fraud to attempt to get the PPP loan. The statutory requirements on the bank or on the lender under the program, the CARES Act itself provides that the lender shall consider only 2 items in terms of loan underwriting, which are very simple: whether the borrower was in business as of February 15th, and did they have employees and pay salary and wages and payroll taxes as of that time. The prior version, just a note of the law that was circulated back in March, it required that the lender only consider those 2 things, and so that created a question, obviously, of how much further diligence a bank was required to do, in that setting in evaluating loans. On the next slide, Tabitha, the first interim final rule that was issued on April 2nd, which was the day before loan applications could be accepted. It was pretty clear, or answered a question, I think, as far as what limited obligations the lender had on the underwriting side. And it was essentially, or is essentially, four things: just to confirm receipt of the certifications, which are actually in the application form that the borrower submitted, confirm information regarding borrower having employees and paying salaries, so the February 15th date, and then to confirm the dollar amount of average monthly payroll costs, which raise another question of how much investigation or diligence is the lender required to do with respect to that number. And the frequently asked questions began to come out soon thereafter, indicating, of course, that a bank only is required to give a good faith review of payroll costs. So essentially, unless you had some reason to believe that there was inaccuracy or not supported by the information and data that had been provided, and there's not anything further that the bank has to do there. And then following Bank Secrecy Acts, the BSA requirements. And so that gets into something we'll talk about in a second, but banks have been criticized in many cases, and there are class action suits out there regarding favoring current customers over non-customers. And, the BSA kind of plays into that, just the familiarity that banks have with their current customers. But those were the four requirements. And then on this slide, the interim final rule gave some help or some assistance there, just saying that a lender can rely on the borrower certifications regarding eligibility. So a lender will not be held liable if a borrower actually had, say, more than 500 employees, or if it misrepresented things regarding affiliates that can play into eligibility, and further provided that a lender will be held harmless for a borrower's failure to comply. So essentially, give some assurance that the loan and the guarantee remain in place, even if there's been a problem or a misrepresentation by a borrower. And then on the back end, with respect to loan forgiveness, we're at the back end of the process for many borrowers right now, and so we've gotten a lot of questions regarding what obligation the lender has with respect to forgiveness and verifying the information. I'm sure you all saw that SBA Form 3508 was issued, I guess, a week ago today, I think. And that form has some clarity on what documentation the borrower has to provide to the bank. But the initial interim final rule back on April 2nd was clear that the lender does not have to verify what the borrower provides, and that's the documentation to support the request for forgiveness. And then there is an attestation in the Form 3508 that the borrower is required to make. And so that's essentially all the lender has to do, is to receive those certifications and then submit the request for forgiveness. We are recommending to bank clients that they use a standard checklist, and we've prepared one that will just be something easy to keep in each loan file to check the box on documentation that's been provided, in addition to just the forgiveness application itself, the Form 3508. But we would recommend that's what banks should be doing at this point. On the next slide, there is a provision that lenders would essentially be held harmless as long as they rely on the information that's required under that 3508, along with the certifications that the borrower is making. Just to note, the CARES Act itself prohibits the SBA from essentially taking the enforcement action against the lender if the lender has received that attestation from the borrower. That is only, again, with respect to the SBA. So we'll talk about some other potential risks there. On the next slide, you'll see that if you just think through how government programs typically run and what other agencies could become involved in an enforcement action or investigation, we've already seen the 2020 hindsight problem, I guess 3 or 4 weeks ago, in the case of Roost Chris and Shake Shack and some of these other public companies that access the PPP program. They clearly were eligible, notwithstanding what the SBA, or at least eligible under the CARES Act, and then the SBA came out further regarding the certification. So, I have no doubt that there will be further committees created and investigations and that sort of thing. One of the hopes is that this is such a broad and widely used program that companies that truly needed the money, use the money to keep employees and to pay the other eligible expenses, that they should be in the clear, and you would just hope would not be subject to too much investigation or issues like that. You're aware, I'm sure, that the SBA and the Treasury Department has indicated that they would audit or review loans above $2 million. I'm not sure what the resources are, whether every loan above $2 million really will be investigated or audited. It also raises question of whether there will be kind of random audits, such as the IRS and some other agencies would do, where they pick a $100,000 loan to audit. So there's obviously some risk there, and just some from the standpoint of the borrower, just to be ready for that sort of thing from a documentation standpoint. The primary regulators, banks' primary regulators, the OCC, put out a notice, several weeks back now, encouraging banks to document lending decisions, and some of that's probably in response to the class action suits that have been filed that are out there, but also requiring banks to track loans to smaller businesses and then businesses that are located in low-income areas. So there's a provision in the CARES Act regarding prioritizing loans to low-income areas and smaller businesses, minority-owned businesses, and that sort of thing. There's been a lot of talk about that recently, that priority really did not play out in the implementation of the PPP. So it's kind of interesting that the OCC is requiring that. Not really sure what impact that will have or what that would mean for a lender if they, for example, had either no loans in lower income areas or a lot of loans in lower income areas. So that's kind of an open question. Kind of an unknown too is whistleblower claims that could occur. And there's a False Claims Act, which is a federal statute, which could allow a private citizen in some cases to report someone that is that's wrongfully received government funding, essentially, and receive a payment or benefit for that. There no doubt will be some whistleblower claims, and those can be typically could be filed by an employee of a borrower, potentially could be filed by any other third party. So it'll remain to be seen how much of a risk that is. The Department of Justice obviously can get involved in any fraudulent or alleged fraudulent activity. So we'll see where that goes. On the next slide, one of the things we've talked to a lot of bank clients about is kind of the reputational risk. Most all banks I've talked to, like I said, they kind of you're voluntarily participating, but it was something that was necessary just from the demand from customers and desire to retain those relationships and I think generate some goodwill, which I think it has done for many banks. One of the things though, and I had a bank client call me, I guess mid-April, and he was concerned that a lot of his customers were making that, they viewed these things as grants and no expectation that they'll ever, potentially have to pay anything back. And so we talked to a lot of folks about just kind of managing that expectation, staying engaged with customers so that they understand that forgiveness does not just happen. It requires documentation and obviously how you spend the funds and that sort of thing. And so most banks that I've talked to have had that weekly discussion with their customers, working through with them documentation as the covered period progresses, I think is very important. There is a provision in the CARES Act that once a report or a request for forgiveness is submitted, that the lender has 60 days to decide. And so it's still not clear how the SBA's involvement with that process will work. The 3508, I think in most cases, will end up being electronically submitted to the lender and then turned to the SBA. So how soon thereafter the SBA really is able to conduct any confirmation of what they've received and give a give a green light to forgiveness, it'll remain to be seen there. The one provision in that form provides that the SBA can tell the lender essentially to disapprove of a loan forgiveness if the SBA determines that the borrower was not eligible in the first place. And so that raises a question of how much investigation the SBA plans to do with these things, because that goes not from not looking at forgiveness necessarily and how you use the money, but whether you were eligible to begin with, or whether a borrower was eligible to begin with to receive a loan in the first place. So there's some questions about that and issues as far as how this thing will really work in practice. On the next slide, a lot of articles have been out there and a lot of discussion about, again, banks not providing loans to certain businesses or types of businesses. The CFPB put out a instruction I guess a month ago or so, that just essentially telling businesses, if you think you were discriminated against for certain protected reasons, then you should file a complaint. And I've not seen the result of that, if there have been a lot of complaints filed or not. There have been class action lawsuits that you've probably read about for some of the larger banks, and a couple of what I would call smaller banks have been pulled into that too. That was probably more of a concern really initially because that initial funding went so fast within, I think, a couple of weeks. As I've mentioned earlier, I think there's $500 billion that has been funded, so there's still plenty of room there for other businesses or borrowers to get in line and be able to take advantage of that. One thing, and this certainly is not controlling nationwide, but a court in Maryland ruled that a borrower doesn't have a private right of action under the CARES Act for failure to get a loan. So that will no doubt continue to be litigated. And on the next slide, the interim final rule that was issued at the end of April, it dealt with disbursements and funding of loans and then reporting of those loans by lenders to the SBA. And it required that lenders electronically file the Form 1502, which is just an SBA form that's used just in the normal course for, I believe, for all SBA programs. And so it provided those had to be filed within 20 days after the loan is approved, or May 18th. So had some time there. We have been in touch with SBA on several occasions regarding that, and just asking when the updated form and the process for that would be issued. And it was issued actually yesterday on May 21st. The Form 1502 was issued under a procedural notice. And so if you haven't seen that, I think we have it up on our website, but take a look at that. It just outlines the process that banks would need to follow for submitting it. One important thing to note there is that the notice warns of a potential clawback on processing fees if a lender fails to fulfill its obligations under the rules. And so those are on, again, we talked about earlier, just the underwriting rules are fairly limited, but ensuring that a lender has checked the box to follow those requirements are, again, just important. No doubt that there will be situations where we assume these processing fees have been paid to a lender after the 1502 is submitted, and then SBA conducts some form of audit or investigation and attempts to claw those back. So that's something to keep in mind as well. And at this point, I'm going to turn things over to Mike Moore.
Thanks, Robert. I'm really happy to be here with y'all this morning. Want to encourage you, if you have a question or a comment on anything, as at least as I go through what I'm going to talk about, hit us up in chat with a question, and I'll keep my eye on it as it comes through and try and answer questions that anybody has. I'm going to switch gears maybe completely from what Robert was talking about and talk about changing from y'all's situation as a lender to y'all's situation as a business that is facing the daunting task, I believe, of of how, when do we reopen? How do we reopen? What's the new world going to look like? And as I have been telling every one of my clients for the last couple of months, we are all flying by the seat of our pants at this point, and things change kind of regularly. So on the next slide, I've given some guidance places that you can look to determine what the CDC and what OSHA are saying about reopening, about what guidance they have for businesses. And I want to say two specific things about that, and then we'll move on to some other issues. First, the CDC, as I'm sure some of y'all have seen in the last, I think, 24 hours, have somewhat amended their guidance on the ability of the virus to survive on surfaces. And so all of what we have been told about washing your hands and hand sanitizer all the time and gloves and all of that may not be as important as today as it was before. The other thing, the OSHA guidance that I've referenced, and I apologize that that's not a link, but that is a PDF document that OSHA has put out, and that specifically says that employers should require masks to be worn if practicable. So let's move on, and we'll kind of talk about other things. There's also local guidance and industry guidance. I put on there the example, the Arkansas Dental Association several weeks ago when the governor allowed dentist office to open back up. There was a loud outcry of fear because the chances of transmission in a dental office are extremely high, and so the Dental Association came out with some specific guidelines. I don't know that the Bankers Association has. My conversations with people indicate that there isn't any hard and fast guidance, but obviously that's something we want to keep up with. All right, let's move to the next slide, which is stay informed. And the way you do that, the way I do that, is I read my email and I try and watch the governor every day when he's on at 1:30 to see what the day's numbers are, what the trends are, and whether we're looking at further reopening or kind of taking step backs and closing some things up that have been open. As I said at the start, everything changes every day. And what I believed was the case, what I believed was guidance a week ago is not necessarily the same today. All right, so let's talk about some of the specific ways we start thinking about how we're going to open our business up. And we have had to go through this here at our office to decide how we do things. I just got through the other day talking with a client that has had their building that houses 250 odd employees closed down for 2 months and trying to decide how they're going to reopen. So we're talking about how the workplace is laid out, including how many restrooms there are how many employees there are per restroom, whether we are a dense workplace, because that seems to be what the common denominator in hotspots are density is the density of people. And so is this a workplace that has one employee every 120 square feet or one employee every 300 square feet? Are we all in cubicles with no walls to the ceiling, or are we all in offices where you can close the door? Is our workplace where we have a lot of customer, vendor, or third-party access? And so I'm thinking about I do banking for myself, for my parents, and for my kids, and so I have the opportunity to go in a lot of different banks branches, and they're all laid out differently. And so I may have a branch manager that's in the office with a door, and I've got tellers obviously at an open teller window, and I've got people working drive-through, and different branches have different security measures generally about whether you've got to be buzzed in, how many entrances and exits there are, and so forth. So those are the things we need to start thinking about in determining how we reopen. So the first goal always has to be employee health and safety, because if we have an employee get sick, then we're going to likely have to close, or we're going to have to close that branch down for a period of time to clean it. We're going to have to send some number of employees home to self-quarantine as they wait out that period and get tested. The next goal we have is to keep our customers healthy and safe. We want to get our employees back to work. All of y'all who have gotten PPP loans and they're about to run out, we got to figure out a way to get our employees back to work. We want to, in the process of getting employees back to work, we want to avoid unemployment claims for those who don't come back, and we want to avoid lawsuits by employees who may claim that they've had their rights violated under, for example, the Americans with Disabilities Act, the Family Medical Leave Act, the Emergency Sick Leave and Emergency Family Medical Leave Act under the Family First Act, which was, I think, the second of the Coronavirus Acts, and to avoid potential workers' comp claims for people who get sick at the workplace. So how do we what measures do we take to hit those goals? We can move to the next one now, Tabitha. So here are a lot of things that different people are considering. A questionnaire for employees and visitors, taking the temperature of employees and visitors, masks, gloves, and I say barriers in the workplace, and what I mean by that are the plexiglass shields that would be between a customer and, in y'all's circumstance, a teller or a loan officer. That those barriers seem to be in most significant retail establishments that I go in, and I think are a must use if you're going to open teller windows back up in a lobby. So let's back up just a moment, Tabitha. Let me touch on some of these. A lot of people, for example, my parents are in a nursing home, and they require the questionnaire that's, I believe, on the Department of Health website before anybody enters. They also take everybody's temperature who walks in the door, and that may be a workable solution, or some of those workable solutions in some circumstance. For example, my client, who has a 250 employee workforce in one building and has been working almost exclusively remote for 2 months, they're going to require that entry questionnaire from every employee one time before they come back to work. We are not here doing that questionnaire for our employees. one of the things we are doing is having employees disclose travel, recent travel, so that we can determine whether somebody's been in a hotspot. My grandson goes to a school for kids who are getting therapy, and all of those kids have their temperatures taken before they walk in. I believe for a bank with a branch with a single entrance, that might be a measure that could be taken. The difficulty for y'all with a small branch is that there's not going to be a greeter or security person who could do that, and most of the employees are tellers behind the window, and that may just simply not be something you can do. As I mentioned a few minutes ago, the OSHA requires, or the OSHA guidelines suggest that an employer should require masks to be worn by anybody in common areas, and that would include customers. And as the governor's requirements for restaurants require all restaurant customers to wear masks between the door and the table. Now, I think for you guys in the banking industry, having customers walk in the door with a mask on is kind of one of those things we don't like to see, and because we don't know who they are. And there, in my mind, I remember the old movies with the bank robber with the mask on. So there's a connotation there that's difficult, and it's probably not good practice to allow somebody to walk up to the teller's window with a mask on without identifying themselves first, or at least giving you some comfort that they are not the quote unquote bank robber. Even with the plexiglass shield, it might not be the best solution. One of the ideas that I came up with that may be workable is that there are all sorts of wireless cameras. I have them at my house for security purposes, which would allow you to have a customer identify themselves by at the door before they're buzzed into the branch, to identify themselves by holding up their driver's license and pulling their mask down before they come in, and the teller can look on their screen to see, to make sure that visitor is in fact a customer. The gloves issue, I'm not sure where we're going to go with that, given the recent change in the CDC guidance. That may be something that is not necessary. Obviously, tellers are handling things that customers give them, and so it would be my suggestion that tellers wearing gloves is probably good practice, at least for now. All right, Tabitha, let's move to the next one. But one-touch efforts is what we're trying to do is limit in our kitchen area, for example, how much we need to touch to be able to serve ourselves with a drink or a cup of coffee, and whether we can have a box of wipes there, a dispenser where people can grab those surfaces without touching them with their fingers. We have trash cans by all doors where you have to grasp a handle to get through. We try and wipe down and or spray common area surfaces every day. In our building, we have issues with elevators and trying to minimize the number of people who are on the elevators. There's always an issue with restrooms because that's a place where it's difficult to practice social distancing. And so there are all sorts of ways that you can say we're going to limit restroom access one at a time, two at a time, so forth, and that would be something you would consider based on the density of the workforce and the availability of multiple restrooms in the area. In our firm, we are stressing limiting movement, and I move from the elevators to my office, and I don't go see Robert in his office on a different floor when I need to talk to him. And therefore, if I get sick, I don't have to have people from another floor go home because they've been around me. So we need to train our folks on the use of masks and gloves, and reinforce hand washing protocols. And I put it in training, but maybe it's more in enforcement. As we start to become more dense with people coming back to work in our firm, and as y'all start to become more dense with more people coming back to work in your branches and in your offices, you have to have people who are willing to call people out on their failure to follow the rules. I was at an outdoor gathering the other night, and there was a pavilion that had 60 people under it, with, in some cases, 6 people sitting to a picnic table, and nobody had masks on. And I shook my head and I left, because it was like, I couldn't believe that people nobody did anything. And that's the struggle we're all going to have as we start reopening. And it's going to be, you're going to have to look at your coworker and say, you need to put your mask on. And so for the employer to employee issue, it is absolutely important that we communicate upfront what we're going to do, and that we keep communicating that on a daily basis, and that we timely communicate any changes in guidance. So we need to have discussions with specific employees about issues they might have with a disability, people who are in at-risk categories, people who have child care issues that are simply going to be ongoing, even though more child care facilities are going to open, and people are hopefully going to have better access to summertime child care issues that will remain. And then, of course, the big problem we're all going to face the next 90 days is people going to say, I worked from home just fine. I want to continue doing that because I'm scared. And we've got to, I think it's important for us to minimize, in our business, to minimize remote work, because while we can maintain a certain level of performance remotely, we can't grow our business. We can't advance our practice. We can't do better unless we have the ability to work together and brainstorm and all of the things that happen when we're around each other. And so what we're advising our clients, and they've come up with a somewhat of a template, is that we need to make a clear communication to those employees about our plans for reopening, to recall them to work, to get them back. And we have to, the first thing we have to do as an employer is to tell them that it is our goal that everybody has a safe workplace and the ability to work without getting sick. We have to tell them first to avoid any unemployment or potential ADA claim that they're being returned to the same job and return to the same pay level. If we get our folks back to work and somebody tests positive, and I apologize, I put this slide a little bit out of sync in here, but here's what we do once we get back. We need to treat a positive and a suspected but unconfirmed case as the same. We need to isolate somebody who tests positive, and that 99 times out of 100 means send them home. We need to inform and isolate other employees who are working in that area of the positive person, and that usually means sending them home. But we're not gonna identify the employee who is sick unless they give us permission. We need to close that workplace down and disinfect it thoroughly. And we need to notify customers, vendors, and building management if that's appropriate. So in our recall process, we have the $600 dilemma, as I'm sure most of y'all have come to know it. And that's the $600 per week bump on unemployment benefits that everybody has gotten, which I would suspect means for y'all that any teller who has been laid off of work is making more on unemployment than they were at work. It is clearly anybody that makes between $30,000 and $50,000 a year is going to make more sitting at home than they do working. And so what we have to do is find a way to make sure that we can avoid the unemployment liability if those people refuse to come back to work. And that is why we have to have an unconditional offer to return, and we have to avoid them being able to make the claim that they were justifiably afraid of getting sick in the workplace. The Department of Workforce Services has been pretty clear that they will deny benefits to someone, and then that employee will have the burden of showing that they had a good faith reason for refusing that job offer. That's why we need to talk about high risk employees and ensuring that we communicate all of the safety measures that we are taking in order to avoid a reasonable claim that somebody is going to get sick. So how do we do that? We develop a plan that provides a safe work environment. We prepare a return to work letter with the start date, hours, wages. We list everything we're doing to create that safe work environment. We reference that we're following CDC and OSHA guidelines. We specifically put in there, if you have concerns or requests for accommodation, here's how you do that. If somebody says that they refuse to return to work because they're scared, then we have a document that says, we have communicated to you that we are following all government suggested guidelines to make a safe workplace. You have refused to return to work and have not offered us any legitimate explanation for your fear, given our safeguards. That is so that we can submit that to the unemployment people if there's a claim, and maybe more importantly, if they come in and say that they had some disability that we did not accommodate, we show that we attempted to engage in the interactive process, which is what is required with the under the ADA. Obviously, if somebody has a legitimate concern, we want to make sure that we do engage in that process. And you know, the reality is that somebody might give us something, some reason to change what we're doing. I want to talk just a few minutes to leave some some time for questions about the shared work program. And it is something that a lot of our clients used at the beginning to instead of laying people off. And it may be something that a lot of businesses want to do as their PPP proceeds are all paid out, and they still are not able to work back up to full speed. So I'm going to work through the shared work program, and if anybody's got any desires to learn further about it, put it in the chat or email me after the program, and I'll be happy to try and help you walk through it. It is particularly beneficial to employers and employees. Employers who engage in the shared work program do not have their experience ratings affected specifically, and generally the benefits paid out under the shared work program are fully funded by the feds, and thus do not drain the substantial unemployment trust fund that the state has right now, or had 3 months ago. The employees receive partial wages, partial unemployment benefits, plus the 600 weekly benefit under the CARES Act. So the requirements are that the employees' normal weekly hours must be reduced at least 10%, but not more than 40%. They must otherwise be eligible to receive unemployment benefits. They have to be able and available to work. And you can't have laid off more than 10% of the employees who are in the program within the last 4 months. You then have to certify that had you not had the program, you would have had to lay off at least 10% of those employees. Important to know, this is not, you do not have to make this program for all of your employees. Basically, the shared work program that you have is only the people you put on the list. And it can be any subset of your workforce. How it works is you submit an application to Department of Workforce Services, which is a relatively simple application. They have a handbook online that you can get this. We've been doing tons of them for our clients over the last couple of months. Department of Workforce Services approves the plan. That you can't do it unless they've approved your application. And then your employees have to submit an individual application for unemployment, and it has to say on that application the reason for unemployment, shared work plan. Then there has to be a joint submission weekly of employee and employer for their hours worked, gross earnings, and there's we've helped kind of with the Department of Workforce Services get a streamlined reporting form to do where we can do it somewhat electronically. This is a program that before 3 months ago was rarely, if ever, used by anyone, and so it has mushroomed into a huge administrative nightmare for Department of Workforce Services, and it is a substantial administrative burden on employers. All right, so considerations. My employees are higher earning. Will they still be eligible to receive unemployment benefits on the shared work program? Yes, that is one of the big benefits, is that if you basically make more than $641, I believe, per week in wages, even if that is a 30% reduction in your hours and earnings, you will not receive any unemployment benefits. But on the regular, partial unemployment, whereas the benefits will be eligible for people under a shared work program, no matter how much they make, if their earnings have been reduced. And can you apply for the program if you've already reduced hours? Absolutely. Can you apply for it but not implement it till later? Yes. Does it apply to exempt employees? Yes. It's it is somewhat cumbersome for exempt employees, but it still can be done. And if you choose to lay off employees after you create a shared work program, then that ends that program. And there are some ways to skin that cat, because you can do subgroups of employees. If you think there might be a part of your workforce that will be laid off later on, then you would do a subgroup for them. That way, if they get laid off, it doesn't affect the program for the other employees. That's kind of a quick overview of the shared work program. It's somewhat more complicated than that, but like I said, if anybody's got questions or desires to do that, then I'd be happy to answer those offline.
Hey, Mike, thank you for that. And everybody, we appreciate you all joining us today and appreciate the opportunity to talk to you. One thing I want to note just real quick, we are sponsoring a webinar this afternoon at 2 o'clock to review and discuss the Form 3508, which is the loan forgiveness application that was issued last week under the PPP. And so if you would have any interest in that, just go to fridayfirm.com under events. You can sign up for it. But again, we appreciate everybody joining today, and hope to talk to you soon. Thank you.